have set this case down for 15 minutes per side. Good morning.
Good morning, Your Honor. Okay, please the court. I'm Steve Brannick of Brannick and Humphreys here representing the appellant, Mr. Kritikos. If I may, I'd like to reserve 5 minutes of my time for rebuttal. We see this case very simply.
Oh, that's good. It's hard to see that simply.
Well, it's only a 35,000-page record, right? But it actually is very simple. When this court reversed, it said there's a remand for retrial and damages. That meant liability was settled. Well, the trial judge disregarded that mandate in several important ways that resulted in an unfair trial for our client and resulted in the verdict. In the second trial, it was completely inconsistent with the verdict in the first trial. First, the defendants were allowed to retry their all-or-nothing defenses. Basically, they argued in the first trial that Mr. Kritikos had accepted the work, and they brought those under the theory of estoppel and waiver and release and accord and satisfaction, and those claims were all tried to judgment, and they lost. Well, in the second trial, they got a chance, even though we were there just on damages, to retry those all-or-nothing defenses again. That was wrong.
My understanding is there was some discussion pre-trial after the remand of what the issues were actually going to be presented to the next jury. And my understanding is the appellant agreed that one of the issues to be tried is proximate cause. Agreed?
Sure.
Okay. If that's the case, then in assisting the jury in deciding the proximate cause issues, why wasn't it appropriate to get into the affirmative defenses?
I don't think those affirmative defenses, those aren't affirmative defenses that go to proximate cause. Those are affirmative defenses that go to whether you're liable at all, whether there was an acceptance.
Yeah, and I think part of the problem is, and there was some discussion in the transcript, as I recall, that the use of the word liability is problematic because, the reality is in any lawsuit, you're going to have to first show a duty, and then you have to show a breach. You're going to have to show that the breach was the proximate cause of injury, and then there was damages. So, liability is kind of the overall umbrella that if you prove all those things, someone's liable. But, as I understand it, the jury was told both sides breached the agreement.
Right.
The question you have to figure out is, what are the damages, and were certain actions the proximate cause of the damages? So again, if that's what the jury was tasked to do, which I think was proper under the remand, I'm still not sure why it's inappropriate to talk about affirmative defenses.
Oh, it's certainly appropriate to talk about some affirmative defenses. For example, the affirmative defense of mitigation and damages was perfectly appropriate. There was an argument about how much of the damages was caused by the fact that the project shut down and sat there unattended to basically for a year. That's fair game. But you can't, when you already litigated in the first trial an argument that Mr. Kritikos has accepted the work, and you lost that, and you go back for a retrial on damages, you can't then ask the second jury exactly the same question that you lost on in the first trial, that Mr. Kritikos accepted the damages. That's not proximate cause. That is a pure liability defense that goes to all or nothing. To look at it this way, we argued that there were a number of different defects in the construction, and we argued that there were a number of different overcharges. If the focus of this trial had been defect by defect and arguing causation and damages defect by defect, that would be legitimate. But what happened here was an all or nothing. They basically got up to the jury and said, you have to award a zero because these damages were accepted. That's just the first of the two big problems. The second problem, I think, is even more obvious, is that you have, one of the big questions in this case was how much of this was caused by the design from the architect, Peter Gluck, and how much of this was caused by defective construction. That was a big feature of the first trial, and the jury came back with the answer in the first trial, and they absolved Peter Gluck of any liability, the architect. So we know from the first trial that all of the issues are construction issues. They're not design issues. The second jury didn't know that. They had no idea that Peter Gluck had been absolved in the first trial. And you'll see when you look at the closing arguments in the second trial that a huge feature of the second trial was pointing to the empty chair and saying, these are all design issues, these are not defect issues, and therefore, jury, you should award no damages at all. That is completely inconsistent with what happened in the first trial, and that's completely unfair. So for those two reasons, we think that we didn't get the trial that we were entitled to the second time around. It's wrong on a number of different levels. First, and most obviously, it's wrong because it's a violation of the mandate. This court's mandate in the first opinion was clear. There's a retrial on damages. Doesn't say anything about liability. Liability was settled. If they thought that there was something confusing about that, if they had some all or nothing defenses that they thought might be a problem, they could have sought clarification, and they didn't. So we've got a violation of the mandate. Secondly, it violates the principle of collateral estoppel. These issues, like whether it's a design defect or a construction defect, were tried all the way to judgment in the first trial.
They were tried as to judgment as to the other defendant, but not as to this defendant. So my concern is there is an exception to collateral estoppel if it's going to create a manifest injustice, and I'm concerned that there's going to be some manifest injustice, if not a denial of due process, when you're now trying to tag Anderson as the wrongdoer, when they never got to litigate whether they did the wrongdoing in front of a jury. It might have been litigated by the person that hired them, that was supposed to be supervising them, but now you're trying to tag the employee with something the employer did, and it's supposed to work the other way around, isn't it?
Well, I have two answers to that. First, the all or nothing affirmative defenses were actually tried all the way to judgment, and Anderson was at the trial and got to argue those all the way to judgment. So there's no question about privity, unfair, manifest injustice in connection with the all or nothing defense.
We'll come back to the all or nothing later, because there's a different concern I have about that.
Yeah. So then as to the second part of your question, they did, in fact, get to litigate this case. The directed verdict happened on the very last day. The only thing that was left was one witness that nobody contended was immaterial.
It might have been that they got to present all their evidence, but the jury never got to decide it, and they really didn't get to argue that. So, again, how can that be fair?
Because collateral estoppel says that it applies if you have the same parties or you have parties in privity. And one of the ways to determine whether a party is in privy is whether there's a mutuality of interest. And as the second DCA case, and the name escapes me right now, I don't have it on rebuttal, but the second DCA case that they cite in their answer brief talks about this very specifically. It says if two parties have exactly the same interest, if they are walking in lockstep, and one of the parties gets the opportunity to litigate something all the way to judgment, the party that's in lockstep with them has a mutuality of interest, and they're bound by collateral estoppel as well. And that's exactly what happened in this case. In the first trial, ARCS, the construction manager, and the Anderson Construction defended side by side. They were in lockstep. Anderson got to put on all of its evidence before the directed verdict, and ARCS was making all of exactly the same arguments, again in lockstep with Anderson, and those went to the jury. Because of that mutuality of interest, there is, in fact, treated as if they were the same party, and so they did get the chance. And what's interesting about this case, this is a much stronger case than the typical case. In the typical case, you have someone who's sitting on the sidelines throughout the entire case, and then there's a collateral estoppel argument about privy or mutuality of interest. Here, Anderson Construction was not sitting on the sidelines. They had a chance to put on all of their evidence. They were in the case all the way up to the end until the erroneous directed verdict. And just, such a shame that happened in the first trial, but that's what we're stuck with. But so there's no manifest injustice here. They're lockstep. They argued arm in arm, exactly the same theories, and the jury came up with the answer. So we think that there's nothing unfair about binding Anderson to the result. And again, as I said, in connection with the all or nothing defenses, they were there all the way to the bitter end and had a chance to present their arguments at closing arguments.
Did the trial court rule as a matter of law that it's all or nothing? What strikes me is certainly they can argue to the jury, you've got to if you agree with this defense, then that means you can't find us liable at all. But it's up to the jury to decide, well, yeah, I agree with the defense, but I don't know that I agree with it as to everything. And so that's what we ask the jury to do, is to kind of make those tough decisions about how far does this defense extend, don't we?
Yeah, and I would agree with that. And if that's the way this case was tried, that we would be in a much tougher position. If they were going, if the case was presented defect by defect and overcharge by overcharge, and they were making these arguments defect by defect and overcharge by overcharge, that's one thing. But that's not how this was presented to the jury. If you look at the closing arguments in the second case, it was presented as an all or nothing decision to the jury. They argued to the jury that Mr. Kritikos had accepted the work. And whether you call that waiver, estoppel, release, accord, and satisfaction, they said that means that there's no liability at all. And they did exactly the same thing when it came to the issue of Peter Gluck, the architect. They argued all throughout the case that none of these are construction defects. They're all design defects. Again, pointing at the empty chair of Mr. Gluck, when the first jury had already determined that Mr. Gluck was completely absolved of any design defects. So the first jury decides that they're all construction defects, and the second jury reaches exactly the opposite result. That's just not fair.
I'm looking at our opinion in Kritikos, and it says when in the court discussing what happened below the first time, that the trial court eventually entered directed verdicts against Kritikos, denying his affirmative defense of set-off. You would agree that would be part of the damages retrial, or no? Set-off? The
Right.
affirmative defense of set-off. Would that have been something that would be retried when you went back down?
Well, the retrial was going to be how much of the damages that is Anderson Construction entitled to in terms of not getting paid, and on the other end, how much of the damages is Mr. Kritikos entitled to as a result of the construction defects, and those two would be balanced against each other.
Okay,
But you
and then
call
it says,
settled.
and finding against his counterclaim for construction defects. But then, you're right, when the opinion goes on to talk about what's going to happen when it goes back, it reverses only on damages.
Yeah, and remands for trial. I mean, it's just clear as a bell. And if they had a problem with that, if they thought that that's going to be too restrictive, and that we should have the right to do more than just talk about how much, but we should be able to talk about our liability defenses, they should have come back to this court with a motion for rehearing or clarification and asked for that. They didn't. So they're stuck with the result of the first case. And so we're supposed to have a remand for a retrial on damages, and that's not what happened here. A retrial on damages does not, you don't get to litigate defenses, you don't get to argue that there are no defects, and you
But
don't
would
get
you
to argue.
agree that set-off would be an issue to be relitigated when it gets sent back on damages? Set-off seems to go to damages, no?
Well, I mean, set off in the sense that each side gets to present
Right.
their, and obviously there's going to be a netting of the two.
Right.
So whether that's under the rubric of set off or just the practical effect of what's happening. Clearly, that's all fair game, but not these important.
Not the liability.
You still have a little time remaining for rebuttal, so if you want to
Thank you, Your Honor.
wrap up right now, we'll hear from the appellees. Morning.
Good morning. May it please the court. My name is Kansas Gooden, and I'm here with my co-counsel, Jack Seiler, Richard Zayden. We represent Anderson Builders. And Judge Shayhood absolutely followed this court's mandate. This court ordered a new trial on damages and the amount of the construction lien, and that's exactly what he did. And to answer your question, set-off is a part of the construction lien, and that it goes to damages as well, and that was tried in this case. And the jury was instructed that both parties breached the contract and that the only thing that they are considering is damages. And the jury was asked two questions. And both of those questions, let me get the exact language, had to do with the amount of damages caused by the other party. And so that's exactly what they were faced with. This was not a de facto liability case, as opposing counsel claims. Kritikos seems to ignore causation in this jury question. And that's exactly where these affirmative defenses were going, where it was causation. They were not all or nothing by any means. Because if you looked
Wait,
at...
let me stop you just a second.
Yes.
So you're saying that looking at the wording of our opinion, remanding for a new trial on damages and the amount of construction lien necessarily means that causation was also an issue?
Absolutely, causation was. And that's, if you look at, and here's the reason why. Just because you breach a contract doesn't mean the person's automatically entitled to damages.
Right, but then shouldn't the opinion have said on causation and damages?
In an ideal world, it should have. It could have been clear. And we did move for rehearing on that after the first case, and it was denied. So we did seek clarification. But essentially, that's what we were stuck with. But the thing is, again, the damages have to kind of flow from the breach. And so that's kind of where we're at. And if you look at the affirmative defenses, for instance, about kind of waiving or accepting the work, there were essentially pay applications, and there was number 33 through 40 that did not get paid. And each of those were getting submitted kind of individually to ARC's, Mr. Kritikos' agent. And so the jury could have looked at 33 only, it could have looked at 40 only, it could have looked at 36 only. There was no all or nothing about this. And with regards to essentially, opposing counsel saying that in the first verdict, we asserted these affirmative defenses and we lost. I want this court to actually look at what the first verdict did, and it's found on 9,798 of the record. So this first verdict says, did Anderson breach the contract? The answer was yes. And then it says, essentially, affirmative defenses prevent or reduce recovery of delay damages. And so the affirmative defenses were only presented as to delay. They were not presented as to defect or overcharge. And so Anderson Builders did not have an opportunity to present any evidence on this. And if we go back into that first trial, it's important to note what the order of proof actually was. Anderson Builders was the plaintiff. They asserted construction lien. Kritikos counterclaimed for the defect, delay, and overcharges. So the order of proof was Anderson Builders, Kritikos, Anderson Builders. After Kritikos' case is when the directed verdicts were done. And so Anderson Builders did not have to put on a defense to defect or overcharges. And here's the proof in the transcript. On page 27,477, Mr. Seiler stated, based on your ruling earlier, we went to lunch, made a bunch of calls, and we did not call witnesses. 2 pages later, in fact, we actually then did not call the other witness that we told you we might have. That's why there's 2 minutes left, because the other ones related to those damages you directed verdict on. Several pages later, on 27,481, Mr. Seiler stated again, that's why Mr. Berger didn't have to get up and speak on negligence. It was gone. The next page. Now, Mr. Berger closed his case because we had witnesses on those other 2 issues. So what Kritikos is trying to do is essentially, because Anderson Builders did not put a defense as to those 2 claims, the defect and overcharge, they're trying to say that you can't defend yourself. And that's what we're left here.
So you made a statement that what the jury needed to determine was what flowed from the breach.
Yes.
Okay? What was the jury told other than both parties breached? Was there any explanation given to the jury either by the attorneys in argument or the court in instructions, this is what the breach was for each party? Was there some explanation of what the breach was?
I don't believe so. If you go through the jury instructions, I believe it's very basic that each party breached the contract, and that was it.
But the jury has no idea of what that means when you say they breached the contract. How on earth is a jury supposed to figure out what flows from that? I'm just puzzled about what this second jury must have been struggling with back in that jury room trying to figure this case out. When, they're told the parties breached, they're really not told how they breached, and they're supposed to figure out what flowed from that and what caused what.
Well, and I think the jury did eventually learn through the evidence exactly what that breach was. Mr. Kritikos was claiming that breach was faulty construction, and overcharges that Mr. Anderson Builders did. And Anderson Builders was basically claiming, I didn't get paid. So I think the jury was very aware of what those breaches were. Again, faulty construction and not getting paid. So I don't think the jury was completely kind of left out of the cold as to exactly what was going on, because there was evidence as that. The other thing I wanted to go over is, so ARCS was not held liable for Anderson Builders in the first trial. And again, if you go back to the complaint against Kritikos versus ARCS, and this is the Fifth Amended complaint, and this is found on 8,557 of the record, and you look exactly what was alleged. They alleged ARCS breached that contract by 1, failing to monitor job costs, cash flow, and accuracy thereof. 2, failing to review and certify amounts due to the contractor, to the general contractor. 3, failing to obtain bids for subcontractors and supplies for delaying in construction. And 4, failing to detect and in fact perpetuating major construction and design defects. There's no allegations of vicarious liability, basically saying they're, liable for Anderson Builders. There's none of that. And notably, in support of an MSJ that was filed before the first trial, Kritikos even filed an affidavit, a sworn testimony, that says that ARCS performed services in a defective and fraudulent manner, and that Kritikos terminated ARCS' contract as a result of the various breaches thereof, of that contract with ARCS. And that's found on page 136 of the record. And so Kritikos' claim against ARCS was ARCS' separate contract, because remember, there was 2 separate contracts, and it was a breach of that contract. It was not for actions of Anderson Builders. And I think that is one of the key facts of this case as to why equitable estoppel cannot apply. Because, again, these 2 parties, different companies, different roles on the job, separate and independent contracts, and different issues were litigated. And it's important to note, so at the first trial, when the directed verdicts were going back and forth, the judge granted as to Anderson Builders on defect and overcharges, and ARCS tried to make the argument, well, kind of what's good for the goose is good for the gander. I can get the DV too. And Kritikos opposed this. And Kritikos said that the DV doesn't apply to ARCS because there's different contracts and different issues. And that's on page 27,487. And so now they're kind of taking a whole contrary position and saying, wait a minute, it absolutely is binding on them. Whatever happens to ARCS happens to Anderson Builders. And so I do think there is an estoppel issue there too, judicial estoppel, for taking that contrary position. And there was also an allegation, too, that Anderson Builders pointed to Gluck at the second trial, and that's not 100% accurate either. What Anderson Builders did is actually point to ARCS, who had been held liable. And they said ARCS, as Kritikos' agent, accepted the work. And they never said that Gluck was negligent. They argued that it essentially designed what was given to them. And if you look at the actual testimony kind of going back and forth, the only evidence that I saw as to actually negligence of ARCS actually came out of Kritikos' own expert, Robert Bitterly. And that's on, I think, 1849 of the trial transcript. He said that Gluck's plans were insufficient to build this house. So that's the only thing that kind of hinted at Gluck could be held negligent, and that came from their side of the table. And again, we were pointing at ARCS, not Gluck. So for these reasons, Anderson Builders did not have a full opportunity to litigate construction defect and overcharges in that first case because of the directed verdict. And so to now turn around and collaterally stop them from defending themselves and to try to bind them to a verdict to an unrelated party is absolute a manifest injustice. It would deny them due process. And this court stated in USAA versus Sells, It is a violation of due process to collaterally stop a party who has never had an opportunity to present evidence and arguments on his or her claim. And that's exactly what's going on here.
But, I mean, you're arguing fairness, but aren't we really stuck with what the words say in the opinion? And that's kind of the problem I'm having. I mean, I see where we apparently said what the directed verdicts were entered on, but then when we go and tell the trial court what to do on remand, that doesn't get mentioned. Causation doesn't get mentioned. Whether you had the opportunity to present your case because the DV was entered doesn't get mentioned. The only thing that gets mentioned is we're sending this back for a new trial on damages and the amount of construction lien. It doesn't say whether there should be a construction lien, or it just talks about amounts and values.
Well, it's our position that causation is part and parcel of damages, because again, we're here on a breach of contract.
Right, but
So
if I
it's-
remember my negligence code, there's 4 elements, and causation's not subsumed by damages.
Well, this was a breach of contract claim.
Even-
And again, this duty breach damages are the elements of breach of contract. There is no causation like there would be with negligence. Again, breach of contract action. And so that causation element is assumed within damages.
Do you have some law that says that?
Basic
Good
horn
argument,
book.
though.
Basic horn book law, but contract
When in
101.
doubt, when in doubt. Corbin on contract, right?
And so, this was,
A good read for this evening, ladies and gentlemen.
this was a retrial on damages and the amount of construction lien. That's exactly what Kritikos got. And so he had an absolute fair trial here. And we think their entire case here is kind of based on false premises. That essentially ARC spines us, that we're not allowed to present any evidence to defend ourselves. And we think that they're essentially misconstruing this court's opinion. And again, this is a fair and impartial trial. And we don't believe that Kritikos is entitled to a third bite of the apple to try to receive a more favorable verdict. And for the foregoing reasons, we ask this court to affirm the judgment.
Thank you very much.
Thank you.
I believe you have little time left.
And what was it you said when you first got up here today?
Well, I'm going to say it again. Let me try to boil this 35,000-page record down to its essence. I've got 3 points to make. First, they argue that this was not a de facto liability trial. All you have to do is look at the closing argument in the first case and look at the closing argument in the second case. And in the second case, particularly look at record 5494 to 95.
Say that again, please.
5494 to 95 and 5538 to 39. And that's basically where they say we win because Kritikos accepted all the work, and we win because these are all design defects and not construction defects. And then also look at their brief, page 9 to 15, and read the argument they make in their brief and ask yourself, does that sound like a liability argument or does that sound like a damages argument? I have no doubt that you're going to say that's not a damages argument, it's a liability argument. So that's point number one. That's all you have to look at. The second point, again, on the issue of the acceptance, they tried that acceptance argument all the way to verdict. And Anderson got to make that argument in connection with this delay claim. And in fact, the jury reduced the damages to Mr. Kritikos as a result of that argument. They're basically arguing that they get to ding Mr. Kritikos twice on that issue. They tried it all the way. The first jury ruled, and that should have ended the matter. And then the third point I want to make, and this is, I think, the point that you were getting to, Judge Connor, is look at the inconsistency between the first verdict and the second verdict. It's because the second jury was completely in the dark. They didn't know that the ARCS was found violent the first time around.
Do you agree that that's what the second jury was supposed to decide, is what flows from the breach?
We wanted the second jury to know that ARCS was found liable the first time around. We wanted the second jury to
But
know
isn't
that
the
Mr. Gluck
concept
was
of
found.
proximate cause, because you agreed the jury had to decide proximate cause, and you kept saying a number of times pre-trial when the discussion was occurring before the court, these are the issues to be tried. You said
Right.
on more than one occasion, you can have breach and zero damages. So proximate cause is the issue. So if proximate cause is the issue, then it seems like the jury is supposed to decide what flows from the breach.
Right. And
what's
so-
proximately caused by. So do you agree that there was no explanation given to the jury as to what the breach was? The court simply said both sides breached, but the lawyers didn't explain to the jury what the breach was?
We wanted to explain, they didn't want the jury to know anything. We wanted the jury to know about the liability verdict.
No, you wanted the jury to know about what the first verdict was. Different issue. The issue is in what way each party breached. Apparently, neither side gave the jury any information on that, and the court didn't instruct them either. And, there was a comment about, we apparently didn't properly educate the Fourth DCA on the first appeal, and that's probably true, but it also strikes me, neither side properly explained to the jury what this case was all about because you never bothered to explain what the breach was.
We wanted the jury to know a lot more about this first trial than the judge allowed the jury to learn. That's the problem here, and that's why you ended up with an inconsistency between the first trial and the second trial. And just in closing, this causation argument. Again, look at the closing argument for the first trial, the second trial, and their brief. You're not going to see one word about causation. These were not causation arguments. They were making the fundamental
Liability.
argument on liability. It's as simple as that, and if you look at those two closing arguments in their brief at 9 to 15, you'll see that it's clear. For all those reasons, we think that the judgment below should be reversed.
All right, thank you so much.